Dear participants, a very warm welcome to this early afternoon webinar. As president of the European Law Institute, it is really my great pleasure and privilege to welcome you all to this webinar on a new project of the ELI called Foreseeable Amendments to the European Commission Proposal on the Recognition of Foreign Filiations. Indeed, in July 2023, the ELI Council adopted this theme as a new ELI project, which aims at proposing amendments to the above EU Commission proposal tabled by the Commission on 7 December 2022. The proposal for Council regulation on jurisdiction, applicable law, recognition of decisions, and acceptance of authentic instruments in matters of parenthood and on the creation of a European certificate of parenthood flows out from the Commission President von der Leyen's pledge to ensure that if you are a parent in one country, you are a parent in every country. Of course, one should understand if you are a legal parent, a parent on legal terms in one country, you are also a parent in every other one. The ELI project team will scrutinize the rules of the proposed regulation from 4 specific perspectives: children's, LGBTI persons, and women's fundamental rights, and the underlying EU primary law, especially concerning the free movement of citizens. Based on its analysis, the project, as we will hear by the project reporters, will develop a position paper and then potentially elaborate model rules in the form of desirable amendments to the future EU regulation. The ELI project details are accessible on ELI website, so do not forget to go there and look at this very important project. Before giving the floor to our wonderful panelists, which I will have the chance to present to you as they speak, let me remind you that the chat function has been disabled, that you can and should put all your questions through the Q&A function, and please do not wait until the end to pose your questions. We will answer your questions then orally at the end, but of course, the sooner the better, also to have a kind of flow of questions to ensure a very interesting Q&A session afterwards. Now let's start with the presentation of the 2 co-reporters who will then present the project. First of all, Susanne Gössel, she's a director here for private international law and comparative law at the University of Bonn, specializing on questions of PIL in the EU with a focus on family law matters. She was part of the European Commission's expert group on the recognition of parenthood and is member of the Commission on Reproductive Self-Determination and Reproductive Medicine of the German Ministries of Health, Justice and Family. And the second co-reporter, Ilaria Pretelli, she's legal counsel and expert in private international law at the Swiss Institute of Comparative Law, co-chair of the Family and Succession Law SIG of the European Law Institute, so a special interest group of the European Law Institute, and editor of the Yearbook of Private International Law, among, of course, other many engagements. The international and comparative dimensions of family law, and in more general terms, the need to redress the balance in favor of children and other discriminated subjects by means of private international law and fundamental rights, are her main domain of interest. So Susanne and Ilaria, I am pleased now to give over the word to you. Thank you.
Thank you very much for this kind introduction. I will start with our presentation and approach to the project. And I thought it would be good to give a short case study to see what the problem is. And we can make many cases of parents having a child and then moving to another country and then want to have recognized the filiation link in the other EU country. But I think the most famous, but also very easy to understand the problem case is the Pancharevo case, which has been decided by the European Court of Justice 2 years ago. And the case was that there was a couple, 2 women, a Bulgarian woman and an English woman, and they lived in Spain and were married in Spain. And they had a child together in Spain, and they lived in Spain for several years. So it's not that they went there to give birth. And then the child was born, and they were both, according to the Spanish law, registered as parents, as mothers of the child. And then the question arose whether this child can be registered in Bulgaria under Bulgarian law. And the authorities, the civil registrars and the following authorities in Bulgaria refused, with mainly the argument that you only can register mother and father in Bulgaria, but not mother and mother. So only one mother could be registered. And then the question arose whether this is compatible with EU primary law, especially the right to free movement under EU law. And the European Court of Justice referred to a row of case law which has been developed since 2003, starting in name law, and then also going to the recognition of same-sex marriages, and finally in Pancharevo and another case I cannot pronounce, in filiation, where the European Court of Justice developed the notion that the free movement gives the European citizen in general the right to move with one civil status from one EU country to the other, and the other EU country should not create obstacles in the recognition of the status. Details are unclear because the European Court of Justice always decided on a case-by-case basis. But the general tendency is that status validly established in one member state should be recognized, or impediments of this recognition should be abolished to allow European citizens to use their free movement rights. And the reasoning behind that is that if you have two different status in different member states, means that you always want to use this status, you have to show that it's the same status, and you have a lot of bureaucratic hurdles and problems, and this could impede people to use the free movement because of the hurdles created by the law. And the proposal, which we are going to scrutinize in our ELI project, wants to enhance the free movement of citizens regarding the filiation link between child and parents. And Ilaria and I, we were both in the expert group, and we were both very happy about the proposal, in the meaning that it's wonderful that the proposal approaches the question of international filiation in a comprehensive manner, which means it does not only address, for example, jurisdiction and recognition of decisions or only applicable law, but it looks at all the situations in which a filiation link can be created and then afterwards relevant in different member states. So just to give a very short overview before handing over to Ilaria, we have, after a short introductory part, a part about jurisdiction on filiation registration. Then we have a part about applicable law, like conflict of laws in the strict sense. Then we have a part about recognition of decisions and treated equally, authentic instrument with binding effects. And then we have also a part about the recognition or the treatment of authentic instruments without this binding effect. And then finally, we have, similar to European succession law, the introduction of a European certificate of parenthood, which is also supposed to enhance the portability of a status in the European Union. Ilaria, and now I hand over to you.
Thank you, Susanne. So yes, we are as the project title says, we are looking at foreseeable amendments. This does not mean that we are going to look at all the regulation in terms of article by article amendments, because we have chosen an approach that will look also to the methodology, to the great questions that the regulation poses. Why? Because this proposal is, of course, influenced by the success that the European Union has had to date with a regulation on private international law. And I refer, for example, in family matters, that were to those regulations that were always pioneeristic, that they were always opening new frontiers in the civil cooperation between member states. So we are really, even in the working group, we were really enthusiastic about the idea to open new frontiers and ensure also that private international, through these to the use of private international law, the European Union is promoting a change also in the approach that we have towards filiation. So even into substantive issues. So the methodology that was chosen as in the regulation has been largely influenced by these previous experiences, and there is also a need underneath of avoiding any possible discrimination between children. I think that it is very strong in this matter. The idea that in the past, I mean, the experience of the past, where there was a strong discrimination between children born in and out of wedlock. And because of this reason, maybe this is one of the mindsets that has influenced this solution to have a regulation, a proposal of a regulation that would settle all filiations. All filiations. There is a fear that if a filiation is coming in a family which is composed by a same-sex couple, because the birth, the circumstances of birth would create a possible discrimination for the children. And to avoid this, there has been a choice of not doing as the French drafters of the Projet du Code des droits internationaux privés have done. So they have chosen to distinguish according to the type of filiation. And so they have a specific private international law rule as regards les filiations d'intention, intentional filiation, so with employment of gamete donor, and a specific rule for surrogacy. So this is the choice that is worth thinking about. We have, of course, not to be haunted by the past, but what is important here is to bear in mind the needs of the children. So when is a distinction justified? When it corresponds to the answer of, when it answers to certain needs. And in the case of children born with the employment of art techniques or with surrogacy, there might be, we have to think about it. This will be also one of the aims of the project, to discuss if these children have special needs. In the case of adopted children, for instance, there is a certain consensus that there is a need of knowing the origins of the child, and in that case, all the legislation on adoption, they have rules on this topic. And so there is also a need of discuss on the methodology that was adopted. And now I would like to give again the floor to Susanne on this.
Thank you very much, Ilaria. So our project wants to approach the proposal from different angles. First of all, we want to look at the critiques which came already to the proposal and which probably are still going to come, and want to see whether they are well founded or not, and whether they have underlying issues which might be addressed somewhere. And then Ilaria already mentioned it, and you as well, Pascal. We want to look at the project from different right positions as well. We want to look at the right of the child. Ilaria already mentioned that. For example, the knowledge of origins of children is an issue which is very important, and which might be addressed more strongly in the proposal. And then what we also would like to employ is a feminist perspective, because the recognition of filiation always also comes into the area of surrogacy as the strongest example. And surrogacy, there is always a discussion from a feminist perspective whether the recognition of filiation might enhance the employment exploitation of women in other countries. And that's like the strongest feminist issue which can be discussed, but we will look at the proposal in general from this perspective. And then, of course, we also look at EU primary law, and I already mentioned the case law of the European Court of Justice, which established more or less this obligation to recognize the status, and we want to go into detail and see in how far the proposal might support the recognition of status under EU primary law, or whether there might be collisions, or how this could be resolved, because ideally EU secondary law should enhance EU primary law and there shouldn't be contradictions. And then another issue which might also be interesting is the relationship to the Hague Conventions. Especially, as you might know, the Hague Convention has a project on filiation, especially surrogacy as well, and that might now switch into the development of a convention as well. And then the scope of applications of both instruments should be discussed. Ilaria already mentioned when we want to look at the proposal, we don't want to go into a rule-by-rule approach. We don't want to analyze each rule and then say the second word should be substituted by an and or something. That's in the time frame also not possible. But what we want to do is that we want to look at the chapters and then look at the issue, for example, of jurisdictions, and see how the whole system of jurisdictions in the proposal is composed, and in how far it would be better to improve some rules in the one or the other way. But we don't want to look at each rule for every detail. And so we try to have a comprehensive look once on the whole proposal, but also a comprehensive look on the issues raised by the proposal. And what we also are not going to do is that we look at the amendments of the European Parliament which have been made, which have been, I forgot how many, 177 or something, a lot. And we don't want to look at each of the amendments, but of course we look at the amendments for inspiration, but we don't have the plan to look at each of the amendments additionally to looking at the proposal. Ilaria, and now I hand over to you again.
Thank you very much. Yes, so the idea is really to suggest possible avenues for amendments that could become precious in order to have the proposal adopted if it will not be adopted as it is now, because we are very well aware that there is this reluctance from the part of certain states, and maybe the reluctance is really on the part of the states that we want more to come into the proposal, to adopt the proposal, because this proposal, a regulation of the recognition of filiation within Europe is all the more efficient if we have all the states adhering. So the idea would really be the one of trying to see if there are possible amendments that will encourage the adoption and that will win the present reluctances. And on this, I would again stress on the need to look at the needs of the children and how they could possibly be met, and also not ignore that there is a market. There is a market, and the European Union was born in order to for the reasons of market, but when we deal with family law, we have also to pay attention to the whole social dimension, we will need to have a socially responsible Europe, also not only also as regards family law. And in this respect, I would like again to point to the parallelism with adoption. Is it possible to regulate the recognition of filiation without ignoring, I would say, the parallelism with adopted children, and with the rules that in the adoption instruments are there to fight precisely the abuses of the market? And so the clauses on illegal gains, etc. In this respect, maybe there is a possibility to introduce specific rules instead of relying on the abstract public policy exception, where one can put everything and nothing. And so in order to do this, to have such a wide reflection in such a limited time, and with having in mind possible amendments, we have a team which is very, very diverse as regards its composition, and I would like to introduce it to you now. The persons that are currently studying the proposal, each one with her and his own perspective and his or her own parts of the proposal, are Cristina González Bailfus, who is a professor from Spain and who also was in the expert group of the European Commission, Fabienne Joltzezek from France, Patrick Vautelet from Belgium, who also was in the expert group, Claire Fenton-Glynn, the same from the UK, Laima Weiche from Sweden and Lithuania, Martina Melker from Austria, and Sharon Shakarji, who is based in Israel. So the diversity of the team can bring, we are sure that can bring can bring to the team different perspectives. There is also, of course, the delicate problem of Eastern countries, and I think that there too it would be oversimplistic to say that all the opposition, all the reluctance that we have seen, that we are seeing from member states, is really only confined to a problem with a discrimination against LGBT people. There is not, it would be oversimplistic to think that that's the only problem. We think and we want the team to discuss and see which are the other problems and how can we overcome them. We had this the opportunity with Susanne some months ago and other members of the team to check, to verify this diversity and all the questions raised by the proposal during the series that we had of webinars in May, and to which Maria was also present. And so this would be an arena for us, with your support also and the support of the advisory committee and all the ELI other council members, to discuss these questions and see which are the best answers in order to guarantee the success of the regulation. So I don't know, Susanne, what we could add more in these few minutes before before giving back the floor.
No, I mean, we have 1 minute left. I wouldn't last seconds, but yeah, we are looking forward to the project and we are looking forward to your comments on the project as well.
Yeah.
Okay, thank you very much to both co-reporters for this very interesting presentation. Remember, this is a kickoff webinar, so we are more looking into the future of what is expected, what we hope, and of course, with the help also of the people watching this webinar, either now or later, since it's recorded, you might also get further, ideas and ways. I thought it was interesting to underline not only, of course, the starting point, if I may say so, of the Pancharevo case, for those who take notes, C490/20, because it's as you mentioned, it's one aspect that the regulation goes beyond. And you mentioned several times that one of the aim is also to help the EU to come forward and to maybe have a situation that is based on a wider consensus by the member states. But of course, that's not the only aim we have here. It's really a thorough analysis in order to support not only a kind of political agenda, but really a scientific through understanding of the whole matter. And I think we perceived that, and thank you for these very enlightening opening statements, so that now we can go deeper by looking at what the EU Commission's perspective is. And that's why I'm very thrilled and pleased to have Maria Bilar-Badia with us. She's a legislative officer in the EU Director General for Justice, DJ Just, and after her law degree in Barcelona and a postgraduate in the UK, she has worked first for trade and WTO as a lawyer in an international law firm in Brussels. So you would say, okay, that's nice. Ilaria Pretelli spoke about, you know, the market. Here we have a specialist of WTO and therefore, you know, business and market. And after having worked on the competition law within the EU as well, EU Commission, she's now working on legislative instruments on civil and commercial matters. And that gives the broader view. And I think that's something very interesting and useful probably for this type of regulation. So I'm thrilled to hear what you have to say, Maria. Thank you very much for being with us today.
Thank you very much, Pascal. Thank you very much to Eli for inviting the Commission to discuss the proposal, and to the rapporteurs that we've just heard. I don't think it might be very necessary with this public, with this audience that we have today, to go through what we are aiming at with the regulation. When I say we, I mean the Union, or at least the Commission, I should say. We'll see what happens next. But basically, it's just probably important that indeed the aim is to facilitate the recognition of parenthood between member states, because now this is not always the case, and in particular, and that is a fact that we all have to acknowledge, whereas, let's say, traditional families, they encounter problems, and sometimes they need to go into proceedings and spend money and time. Eventually, they manage to have the parenthood recognized in other member states, but rainbow families, no matter how much energy, time, and cost they invest, they still don't get their parenthood recognized in some member states. So this proposal takes very much this into account. As has been said before, the scope of the regulation of the proposal is very wide, as it aims to cover the recognition of the parenthood of all children. It couldn't be otherwise for the Commission to propose legislation that would not be in agreement with the Charter. I mean, it would have been, from a legal viewpoint, and let alone from a policy viewpoint, to propose an instrument that only covers certain children and not others' children, would have been totally at odds with the Charter, and also at odds with the ultimate goal, which is to facilitate even further the free movement of persons. There's been certain issues that have been mentioned, and on which it seems that perhaps the world may have different views from the Commission. And I'm referring in particular to what you've called primary law. Well, it is primary law. Let's say the case law and the legislation on free movement. The way the Commission understands the VMA case, as we call it, or Pancharebo or Baby Sarah case, the way the Commission understands the VMA case is that indeed the court confirmed that already today member states are required to recognize the parenthood of children, but the court requires that only for certain purposes. So the court, in our view, doesn't require member states to recognize the parenthood for the, let's say, portability of civil status in general. It just requires member states to do so for what we say, for the purposes of rights under union law. And the rights under union law, it's true they evolve, but basically, given that the VMA case is the case in the context of free movement, we understand that this requirement to recognize parenthood actually refers to basically, not only, but basically to the rights on free movement, which basically are right to enter. So in case of travel, holidays of parents with their kids, the right to reside in another member state, the right to obtain a legal documentation for a child so that it can travel with both parents, and then some minor additional rights under union law, which are well, minor compared to the ones I've mentioned. But the way we understand the VMA case is that the court does not require member states to recognize the parenthood of children for purposes under national law. And the rights under national law that we are trying to address with this proposal are rights such as the right of a child to inherit or to obtain maintenance or to be legally represented by either parent in another member state, which we interpret that VMA doesn't require member states to recognize parenthood for these other purposes. It is a fact that in the context of free movement, in the VMA case, the court made it very clear that national identity and public policy are not sufficient grounds to refuse the recognition of parenthood of a child with same-sex parents for the purposes of rights under union law. So the court considered that the recognition of the parenthood of a child with same-sex parents for the purposes of rights under union law cannot be validly refused on grounds of national identity or public policy, because such recognition would not undermine such national identity or public policy. Now, we don't know, because it hasn't reached the court yet, what the court may say if the question arises as to whether member states are obliged to recognize parenthood for purposes of rights under union law, and whether national identity and public policy would be a valid ground for refusal as a blanket refusal. Obviously, in a case-by-case cases, you can always invoke public policy, but as a blanket refusal, we don't know. But we think in the Commission that the court, we hope at least, would consider that in the application of union law, obviously the Charter always applies and that discrimination is not allowed under the Charter. But that's how we see things. This hasn't reached the court. So it is important for the Commission, for everyone to understand why the Commission chose the legal basis of Article 81, family law, rather than Article 21 on free movement. Of course, instruments on private international law are a success, and it's certainly a good way to harmonize certain rules to achieve purposes. But the essential reason why we chose this legal basis is that we couldn't do otherwise. We couldn't, in the Commission's opinion, that includes policy people and the legal service, we could not rely on Article 21 because the case law based on Article 21 and the obligation to recognize parenthood does not go beyond rights under union law in the Commission's view. That's why, since we wanted to go beyond rights under union law and we wanted to require member states to recognize parenthood for the purposes of rights, not only under union law, which also, but also, and in particular, rights under national law, we had to use a different legal basis. And because obviously Article 81 is lex specialis of Article 21, that's an additional reason. But the main reason is really that we didn't think we could use, after VMA, we could not use Article 21 as a legal basis. The rapporteurs have mentioned, of course, the main points that the project aims to address, which are probably the most important from a policy viewpoint, most important points. So rights of children, including origins, feminist perspective, which touches upon surrogacy, free movement, which, well, is it a collision or is it a complement? For us, the case law under Article 21 and this proposal are totally complementary. They don't collide. For us, if child wants to have parenthood recognized for the purposes of rights under union law, any document is valid. A child doesn't need to provide a court decision necessarily or an authentic instrument plus an attestation, because already today under VMA, the court has made it clear that for the purposes of rights under union law, any document is valid, and this public policy and national identity are not sufficient grounds as a starting point. So what we want under this regulation is that if they want to use if they want to request parenthood, not only for rights under union law, but also for rights under national law, then they can use the documents provided under this proposal. But that whenever it comes to rights under union law, this proposal is not compulsory. So for us, it is very important that the rights that have been already acquired by citizens under free movement are kept undamaged, if you want, and that this proposal comes in addition, which of course, if you move to another member state to reside, once you're there, you don't only want to go to the commune or to the city hall which is a right under union law, and say, here is my birth certificate, you're not allowed to ask for anything else, fine. But then if you live in that member state, you want to be able, for example, to benefit from family allowances, from tax cuts, you want to make sure that if your spouse is same sex and the person owns a house, and this person dies, that the filiation link is recognized so that the child can also inherit from the non-biological parent. So what I'm trying to say is that, of course, you can rely on VMA if you just want to travel, or if you just want to make it easier for you in the city hall to acquire residence, but that if you want to go further, then you might need to provide either court decision or authentic instrument or an ECP, and whenever necessary, the relevant attestation. So for us, it's important that this is clear for everyone. Now, from the Hague perspective, again, for us, it is very important that we all distinguish what indeed is ex ante surrogacy and ex post surrogacy, if you want. The union has no competence to tell the member states whether they should all accept surrogacy arrangements, so that they have to allow in their member state a contract on surrogacy, so that a child is born there and then the two intended parents are recognized as such. The union has no competence on that. So whatever the Hague may do on surrogacy, if they agree on some minimum requirements or some conditions, that's fine. We cannot do anything about that. We have no competence on that. All the union can do is to, and that's what we're trying to do under the proposal, is to say, if there's been surrogacy that has been carried out under the national law of a member state on surrogacy, which, as you know, now it's Cyprus, Greece, and in the near future, the Netherlands, that is recognized, that, let's say, that the two intended parents, as established in Greece, Cyprus, and the Netherlands, are recognized as the intended parents, as the parents in other member states, and that the member state, the recognizing member state, does not need to rely on Strasbourg case law, so that it doesn't only recognize the biological parent and then has to require adoption for the non-biological parent. So the Commission proposal goes very far on surrogacy, because obviously now already national law of member states, because of the Strasbourg case law, the member states must already recognize the parenthood of a child born out of surrogacy abroad, whether it's a member state or a third country. That's how we interpret it. They have to. However, Strasbourg only requires the recognition of the biological intended parent, and then that the member state provides for a mechanism to maintain the link between the non-biological parent and the child, which is typically adoption. So that's good. That hopefully all member states already today comply with the Strasbourg case law. What the proposal does is to actually go further, and that's one of the problems that we're dealing with, and council level, is to, and also at parliament level actually, is to that member states actually recognize the intended parents whenever the surrogacy has been done in a member state, not in a third country, not in Ukraine, not in India, not in Mexico, not in California, where national law applies still, i.e. Strasbourg case law, but that whenever it is a member state, that they recognize the intended parents as established as parents in the member state. So this is what we would call, if you want, exposed surrogacy. If you want, we can only require member states to recognize parenthood in cross-border situations, so that they recognize parenthood of a child born out of surrogacy in a member state, but we will not touch, because we have no competence to on whether member states should or should not regulate surrogacy. Same with origins. This has been an issue that we discussed in the expert group. The union has no, I know that perhaps some people are of different opinions, but in the Commission it is considered that the union has no competence to require the member states to set up registers, to ensure that the children will always be able to know and under which conditions who the biological parents were in adoption cases, who the biological parents were in cases where assisted reproductive technology is used, etc., who the surrogacy mother is, etc. This is substantive family law. The union has no competence on that. So we did have an attempt at Commission level to see whether at least a recital on origins could be included, but the people that decide and the legal service actually decided that that made no sense, because we have no competence, so what's the point of putting a recital? But anyway, that's a policy decisions. And finally, on adoption, the policy decisions to the extent that the union has no competence. Because we have no competence, there's no point in putting a recital referring to something on which the union has no competence. That's what I meant. And so on adoption, the proposal assumes that all member states, when they do adoption, they respect the fundamental rights of children and biological mother or parents. And so that if adoption, domestic adoption, meaning where, following the Hague definitions, where the child and the adoptive parents all have the same habitual, all have the habitual residence in the same member state, that if adoption is done in that member state, that then other member states would have to recognize the parenthood of that child resulting from a domestic adoption. And that is covered by the regulation, because of course, for as long as the domestic is done, as the adoption is done domestically with two adoptive parents and the child with a habitual residence in Belgium, for example, everything stays national. But if in the future the child needs to have the parenthood recognized in another member state, then that already falls within the scope of the proposal, because that is already a cross-border situation. Doesn't need to be, for there to be a move of a person, if there's a house to inherit by this person in another member state by this child, that then the parenthood of the resulting from a domestic adoption is also recognized. So yes, domestic adoption is intended to be covered also by the proposal, based on the assumption that all member states, as sometimes has happened apparently, that one says, no, I don't recognize the adoption of this child because in my national substantive law, we do this and that and that and the other, and you don't do that, so I don't recognize that. Well, we propose that in all member states, we're talking always about surrogacy in a member state, domestic adoption in a member state. We are under the assumption that we all respect the Charter and that all member states respect all their international law obligations, and that based on that, they should all recognize each other's adoption. And I will stop there because I think I've exceeded my time. Thank you.
Thank you very much. Thank you very much, Maya, really for this very interesting also distinctions to show how much, on the one hand, fundamental rights, human rights that apply to the EU through the Charter, but then also the private international law aspect allow to go beyond a very strict and narrow approach of parenthood and family law without touching the core aspect of substantive family law, which is not of the EU competence. And I think that has been very enlightening also to explain why, and we might come back later on that, because there are some questions, why and to what extent the European Law Institute's project has to cover or has not to cover the cases from the Court of Human Rights, European Court of Human Rights, because I think that is very clear now from your presentation as well. So thank you very much. And now, as last but not least speaker before our Q&A section, I have the pleasure to greet Masha Jaricevic-Šusterzic. She's a lawyer and a human rights defender from Slovenia, currently working in Association Legibitra as a legal counsel coordinator. And she's also coordinating the Slovenian Rainbow Families Group and is a board member of NELFA, the Network of European LGBTIQ+ Families Association. And she will now bring us to some reflections on recent development in the field, including the NELFA position paper on the parenthood proposal, so that we have also, so to say, an outside view from what the Commission intends to do. Masha, you have the floor. Thank you for being with us.
Thank you. So regarding everything that has been said, I think I will actually focus on the NELFA's position on the current legislative proposal. So we are actually very pleased with the legislative proposal on the cross-border recognition of parenthood within the EU. We are in line with some recommendations that have been already made in the analysis of the proposal. For example, with the PETI committee, especially on the insurance of guidelines and the trainings of the legal practitioners and the non-exclusion of the surrogate-born children, which was already also mentioned previously. So our network considers that the interest of all EU member states searching for adequate solutions regarding the cross-border recognition of parenthood should be taken into account in a compromise reached, which will safeguard those interests while ensuring that the fundamental rights of a child and their best interests are fully respected and protected. So we see the need to protect every child, especially in these cross-border situations, regardless of the condition on how it has been conceived, and regardless of the gender, sexual orientation, and partnership status of their biological or non-biological parents. So for NELFA, it's very relevant to state that the proposal is a child-focused instrument, and the aim is not to introduce marriage equality, same-sex adoption, multi-parenting at the national level, but to protect children and their identity and their relationship to their primary care, so mostly parents. And we also see the need to reassure that the legislative proposal on mutual recognition of parenthood does not interfere with the national family law, which remains untouched. So the member states just need to recognize family ties that were already legally established in another member state. So we are also aware of the strong opinions against surrogacy and the calls on corresponding amendments to the proposal. However, we do think that it's necessary to protect every child, as already mentioned, and we believe that we cannot blame a child for its parents' decision on how to become parents. So actually the Commission itself already confirms that member states are already obliged to ensure that children born through surrogacy continue to be recognized in the state of residence of the family as the children of their parents, as the parent-child relationship was established in the country of birth of the children. And concerning the intended parent, the court clarifies that non-recognition in domestic law of the relationship between the child and the intended mother is disadvantageous to the child, as it places him or her in a position of legal uncertainty regarding his or her identity within society. And the court points out that there are fundamental components that do not necessarily weigh in favor of a legal parent-child relationship with the intended mother or parent, such as the possibility of knowing one's origin, which is also something we'd already mentioned. So member states have also mentioned some concern that the legislative proposal of parenthood touches their national identity or traditional values and the national public order. However, the proposal will only, in our opinion, help to ensure that children can continue their legal relationship with their parents, which was established legally in another member state. So to entails, of course, a certain mutual trust in the aim of finding common denomination, this should be at first, again, the best interest of a child. Therefore, NILFA endorses the recommendation to interpret the public policy exception, which is mentioned in the proposal. We take note that the recognition of parenthood and assisted reproductive techniques are still difficult and controversial topics in some countries. However, the continuation of family ties of children should be always paramount. So we encourage skeptics to maybe look at the case law of the EU court and their jurisprudence. Concerning the European Certificate of Parenthood, NILFA is aware of the complexity of this proposal and the probable workload of civil servants to deal with the provisions. This is why we agree with the recommendation to set up a guideline for the competent authorities how to recognize parenthood established in another member state and to train the staff involved. And the issue of the European Certificate of Parenthood may not be relevant if the rules of the mutual recognition will be easy to understand and to implement. However, we do think that such a certificate would enable civil servants to actually have all the relevant information in one document. Yeah, so to conclude, NILFA wants to, of course, improve the rights of children in cross-border situation while ensuring that the fundamental rights of the child and their best interests are fully respected and protected. So thank you very much.
Thank you very much. Thank you very much for also for giving us NILFA's position, because I think it adds also to the overall picture here that we are discussing. I have now the pleasure to lead into the Q&A section, and we got a number of questions during your presentations, and maybe we can start immediately with one which is linked, in fact, to the European Court of Human Rights case law and the recent Buceanu versus Romania case and others. And the question to the co-reporters is, in a way, whether you will also look at these European Court of Human Rights case law, or whether you will focus on the EU law and primary law. And maybe that's also a way for you to react on what Maria Villar-Badia has said, because, of course, the European Law Institute has no limit as to its competencies. And so, of course, we are not limited by the fact that we would not be competent for substantive family law. And so we might, of course, go beyond what the EU Commission could do. And also, we are not only the EU institute, but a European institute. So we have also a larger picture. So I'm wondering how you want to answer to this question of saying, okay, do you go beyond, because of course there's the charter and there are other aspects that might come into play here. And I don't know whether Ilaria or Susanne who wants to start by answering this question?
I can answer this question. Thank you very much. In general, we are, as you said, not limited to EU law in the strict sense that we only have to look at the EU Charta and primary law as like higher hierarchy laws. And so we will, of course, also look at the European Convention on Human Rights to look at the fundamental rights of the people involved. But our focus is on filiation. So we will focus especially on family life and the best interest of the child, as it's also protected by the European Convention on Human Rights. Our focus will not be in the more preliminary question in how to recognize a same-sex marriage, but we will of course have it in mind and see whether these rights also come into our reasonings or not. But it's not our focus. Our focus is on the child and the family link.
Thank you very much. If I look at the various questions we have some interesting aspects. First of all, many of the questions underline the fact that it is good to have a different angle linked to the various perspectives. And I think that enlightens, of course, this affiliation relationship from the various angles. Now, you have mentioned that, Susanne, but I think also Ilaria, that the surrogacy, let's say, issue or discussion is, of course, very vivid. And someone wrote wondering whether you could exclude surrogacy in your discussion because this is the most contentious aspect on a political level. I don't think that because it's contentious, one should avoid the question, especially in a think tank. But how do you see that? Also, now that we understand also the EU position, looking at ex post and ex ante surrogacy, and saying, okay, in case of ex post surrogacy, of course, there's a kind of expanding force of EU law on domestic law, which is a very different issue than the mere question whether surrogacy in non-EU member states or, let's say, non-EU European states is handled. This is a different issue, and probably you won't, as you said also, you won't touch directly on that. But how will you find the, distinction, the delineation that helps to go forward without opening all the difficult question just because you're dealing with affiliation? So maybe Ilaria, you want to start with that? Yeah, I could see that you wanted to.
Yeah. Thank you. Yeah, so this is, of course, an important issue. And I think that the question that was made by Florian meant more that if we want to propose amendments that would exclude surrogacy for the purpose of favoring the adoption of the regulation. So we will not go that way, I think. But the issue of surrogacy is very complicated, because this is about paying a woman to get for a series, a very a huge list of obligations. She undergoes a full list of obligations, each of which has a particular ethical aspect. So I think it's very hard, in light of this complexity, to make a simple distinction ex post, ex ante surrogacy. So surrogacy is something that deals with the body of a woman. It's the contract itself that it's problematic for many, many countries, but the contract itself has consequences, and we are not looking at the surrogacy as in its substantive aspects. We are looking at the recognition of affiliation. And so what we are looking at is the needs of the child. Does the child who was born with the payment of a woman as a surrogate has specific needs? And how can we address these needs? So I heard about, from Nelfa that the phrase is often repeated. We always hear this phrase saying the child does not have to bear the consequences of the choices of the parent. Of course, each child bears the consequences of the choices of the parent. This is not about punishing a child. It's about seeing which is the best tailored protection for that child. And so we will look at this. Of course, we will look if we want, if there is a need of a specific recognition, a specific questions needs to be answered in in order to protect that child. Also from the choices of the parents, because this is the role of the government. The government needs to protect the people that are not able to do it themselves from the choices of other adults. So in most, I think we are all in agreement that 99% maybe of the case, I don't have the statistics, that the interest is that of the continuity, status continuity, but it's not the only human right that the child has. There are others that are worth being considered, and so there might be also a place in the, so as Maria knows very well, I like always to compare the situation of the hearing of the child. The European Union requires that the child be heard in proceedings that concern that child. So this is a substantive law requirement. It's in a procedure, but it's a substantive law that needs to be seen. And so there is a matter of discussion on this. And I would like to jump to continue, if I take advantage of having the floor, and then I will pass it on to Susanne. But because I find that the question also related to surrogacy from Nina Datoff, Professor Nina Datoff, as regards the feminist perspective. It is not linked only to surrogacy, because the woman's role in reproduction is not confined to bearing a child. It's wider. So the feminist perspective that we want to adopt is wider. I don't know how big it will become, but I think that there is space also. One problem which is ignored is the problem of egg donors, because gamete donation for a woman is not so simple as it is for a man, and there is also a market there, and there is also some studies in medicine that are being developed, and as there are for in vitro fertilized children, from a medical perspective, really, we can move from those and to see which feminist perspective already exists. When I talk about feminist perspective, I'm not referring to one single feminist perspective. There are many of them. And so we have to compare and see which are more relevant and for this proposal, for instance, and what do they tell us. And here I would like also on feminism to give the floor to the other female co-reporter.
I will just speak to hand over to Susanne, maybe because she wanted to also say something on this. Thank you, Ilaria.
Yeah, thank you, Ilaria. You already said most of the points, of the important points. If we understand feminist perspective, not only looking on women, but on inequality in general, and then we can also see that that there might be an income gap, and the situation which we have now is that we have tourism into poor countries and the exploitation of poor countries, especially in surrogacy. And on the other hand, that very rich intended parents have the possibilities to make a surrogacy, which is kind of safe to be recognized. For example, go to California, while poorer families don't have this possibility. So we have also different levels of social inequality regarding establishment of affiliation link via reproductive medicine. And I might also add to Konrad's question, also is triggered by the feminist approach. Of course, it's very interesting to see that there are different from feminist perspectives on surrogacy or egg donation, etc., and see that some say surrogacy should be legalized from a feminist perspective, and others say it should be forbidden from a feminist perspective, and that there are many different angles to look at it. And we look at the project from an academic point of view, so we are still open, and we don't have like one perspective we are following through, but we think it's really interesting to look at it from different angles.
Thank you very much. But of course, the ELI does not only look from an academic point of view, but needs or wants to get to some concrete proposal, as you mentioned also initially with a model rule or something. And that has always, of course, an impact then on what is exactly the angle taken here. So as you preempted a couple of the questions again by your answers, which is perfectly fine, I may just come maybe to the next question that was posed to us, which is linked to the Dutch situation of potentially introducing a multi-parentage of a maximum of 4 parents per child. And I'm not aware of that, but it says there's no official bill, but things may come if there's a change in government. So I don't know how concrete this is. I'm also not sure how much compatible is this first with the UN Convention on the Right of the Child, and then the EU Charter, the European Charter on Human Rights, and there might be issues here. But the question, of course, taken for, if you say we are looking at filiation, you might be confronted to these type of situations in the project and decide what to do with these new or different perspectives and how to integrate them into the full picture. And probably the EU itself might be confronted to some point to that, because of course if one takes as and maybe I can begin with Maria, if you permit me, if you take the situation within the Netherlands, because you said one has to distinguish the situation, whether it's a first cross-border or from the start just a member state question and then becomes a cross-border, then you would say it's a matter that you could decide upon. And so would that be something that could be integrated or is already integrated in the proposal, and how far? Maybe Maria first, and then if Susanna or Ilaria wants to get back to that also.
Yeah, thank you for the question. Indeed, as you said, so the Union would not have the competence to regulate on whether member states should or should not have multi-parenthood, just as the EU doesn't have competence to say that a family should be a man and a woman, or any kind of link between human beings, between 2 or 3 or more, whatever. So we couldn't enter there. But of course, the question has already arisen, and it did arise during the drafting of the proposal. What should we do with multi-parenthood? Because we know it exists in, at least in the US, in 6 states. And we know from some member states that they are thinking about how to deal with this new social development, how to deal with it from a legal point of view. And so, strictly speaking, in the scope of the proposal, given that it is about the recognition of the parenthood as established in a member state, the issue arose, should we also mention that or not? Okay, that decision was made at the policy level higher ups. If you now look carefully into the wording of the regulation, one can make the argument that it's only that the legislator, if adopted as it is now, it's only thinking about 2 parents, because there are references to there to examples or to in the explanatory memorandum where it says either parent or where it says couples, or so very small nuanced language that hints to the fact that multi-parenthood wouldn't be covered. Now, if this was to be taken to court at one point, we wouldn't exclude that the court may consider that, given that the whole purpose of the proposal, as stated, is to cover all the parenthood of all children, regardless of how they were conceived, born, and the type of family. 3 parents are apparently also already, like in particular when there's a donor of gametes and then the other same-sex couple. Let's put it this way, it was decided at the political level that we would not need to add this difficulty in the proposal. And so it is nowhere specifically mentioned that multi-parenthood is covered. If one wants to make a point that the legislator did not intend to cover it, it can make the argument. Now, we don't know what the court would say in the end, but it's a bit blurred in the Commission proposal. It is not specifically covered, let's say, let's put it this way. Thank you.
Thank you very much. Thank you very much also for this insightful and clear statement. Ilaria or Suzanne, do you want to react on that question, or from the filiation perspective? Of course, that plays a role. So
yes, I don't know, Susanna, you want to start?
Yeah, okay, and that's a very intriguing question, which we do not have a clear answer to yet, I would say. But that's also a part we should analyze under scope of the proposal, whether it could be included, should be included. And also in the part of the public policy, it might be part of discussion, because, for example, under German law, the Constitutional Court has decided 20 years ago, and well, we don't know whether he will uphold it or not, that parents can only be 2. And there is at the moment a case pending which might challenge that, but until now, it's kind of the status. So that might be an issue of public policy or not. But also when we look at the best interest of the child, that should be analyzed. But it's a very interesting question we should have in mind during the project.
Thank you very much. Ilaria?
Yes. Yes, this is of course necessary. It is of course necessary to look at this, because cases already will come. And so what will happen if a child who has 4 parents, because also not only in the US, also in British Columbia, in other countries, this can be the case. Also because there are with the same-sex movement, I mean, there is the fact that the family is composed by a man and the woman is not there anymore, and so why not 3, 4, 5, and it's coming up. So what we should look at is, it would be possible to look at, is about how do we select which parents, if they have to be 2. And if we want to escape from this dilemma, which is of course difficult to avoid, we should have a look at the recognition of the parent-child relationship in the other way around. So is the child related to this adult, and is this relationship, is this filiation recognizable, but with regards to one specific person, and which are the criteria that we use to recognize that relationship? So the problem is already there, and not regulating it is not a good idea, of course.
Thank you very much. But what you say is interesting but intriguing at the same time, if I may, because on the one hand, if you have now, let's say 3 parents recognized in one member state, or 4, right? The question you mentioned, if we take one by one and saying, okay, is there with this parental relationship? The difficulty, of course, is the overall picture. And can you really separate the link of one filiation link with the rest? And if you use, like Susanne suggested, the public policy argument, like German would say, okay, for Germany, it's only 2, and therefore public policy argument that allows not to recognize. Does it mean that all 4 are not recognized because it's a kind of, a bundle, or can you choose? And if you choose, then how? But my sense would be that it's difficult to begin to choose, because there you go exactly against the intention of the parents. And if you select, then you cannot really argument with the public policy, because the public policy is the fact that you have 4 in a bundle and not that you have 4 different single link, if I may explain myself. So, or at least I'm wondering how to deal with that in a proper way, so that the public policy argument is not evacuated by the fact that you say, okay, I look at let's say only one of the relationship, because that's the one I need here and now for these papers or for this allowance of support or whatever. I'm not sure I'm totally clear. Maybe I should not have run into that open door, but I don't know whether Ilaria or Susanne, you want to react.
Well, I mean, I think we won't focus on how the public policy exception should be applied, because public policy is a question of each national law with some limits, but national law. But what I imagine is that the national courts, which say we do not recognize more than 2 parents, that they then have to look at which filiation link is against the fundamental, the underlying fundamentals of the legal system. And so each country has to for itself find the way which parental link is the most important, or which are those which should be undone. And may I add, Wendy, you asked whether we also think about undoing parentage. The scope of the Parenthood proposal also includes the contestation of parenthood. So it's not that it's only about establishment. The Parenthood proposal is already considering the, as you say, undoing parentage.
And here we have a question exactly asking whether the project itself will also look at undoing parentage. And I guess, of course, the answer is yes, because this is also linked to the proposal, right? Correct.
Yes, correct. And this is also something we don't have to forget, that filiation is not established once and for all. So there are some filiations that are established once and for all, but also unilaterally, because Suzanne will correct me if I'm wrong, but in the case of a donation, when, for example, a husband, let's put it in a traditional way, a husband consents the fertilization with a gamete donation, with a another man's donation, he will not be able in the future to challenge the filiation on biological grounds. But this is possible for the child, because it can be in his best or her best interest to undo this parentage for many reasons. In Italy, there has been a biological filiation who has been successfully contested by a mother because of a certain dangerous, hazardous mindset and also behavior of the biological father. So the decision on filiation, it has become also a decision, and it is important to distinguish the presumption that we have and that we are used to deal with, and that found the biological filiation and is only a presumption, even though it is in the birth certificate, from the decision, the legal attribution of filiation, sometimes once and for all, unless there are contestation, but not based on biological truth. So these aspects are, of course, of paramount importance, and also when the child is of age, is an adult, for example, there is also a different consideration, which is a consideration in vivo, in the light of what is happening, of the best interests of the child, of the second generation, let's say.
Thank you very much, Ilaria. I see that for the time being, we have covered more or less the questions put by the audience, but maybe there are also questions on your side. And so I suggest I have a round of the table, so to say, and asking Masha Jerichevich if you have a question or maybe a request or a quest to the co-reporters to do something in the project that you would really like to see, because we are still at the start of the project.
To unmute myself. Yes, I would like to thank you very much. I got like an overview of your plan for the project, and we are at NELFA very looking forward to seeing the project involved and to look at it closely later on. So thank you very much.
Okay, thank you very much. Then I get to Maria Villarbadia and maybe to see whether you want to say something about the project to come, whether you think it's a good idea or whether you think, oh, but that will create more focus on some aspects than others, which might create difficulties. Or how do you react on that, and what do you want to say as a kind of final words on your side?
Yeah, thank you. No, I think that project is very welcome. I think that the more people think about important things, the better. I think I mean, all proposals for improvements of the proposal are also always welcome. I'm just not sure to understand exactly though. Are you planning on doing some model substantive law? Because a lot of the issues that we've been discussing may not be able to be taken on board, even if you would like to propose that as a change of the proposal. Might not, for legal reasons or because the legislator decides that they won't do that. Like, for example, on multi-parenthood, we know that member states would not welcome a specific reference to multi-parenthood in the proposal, saying that it also covers, because in a recital it could be specified that it also covers the recognition of the parenthood of a child with more than two parents. But that, well, we didn't. The Commission decided that we should include it, and I don't think that member states, even though some member states actually would like to see that, other member states would not welcome it. So anyway, my question is, are you planning on doing things that either on which the Union has no competence, doing things meaning proposals, suggestions, on which the Union has no competence, like on origins, for example, or on surrogacy, whether yes or no, how to regulate it, or is it more, or you're going to go beyond suggestions to the proposal on that could be at least legally be taken on board, and then go beyond and suggest to make some sort of model law on how to deal with issues such as multi-parenthood, surrogacy, origins, etc. Like saying all the states will have a register and will grant access to the register to this and that and the other. And I don't know, is it a mix of substantive and suggestions to the proposal, or is it suggestions only to the proposal, knowing that some proposals might not be able to be taken on board?
Thank you very much for this question. Very astute question. Also, because in the proposal itself, one can read that it says, and I mentioned it at the start, that after position paper, there will be also potential model rules. But I would like to hear the co-reporters about that, because
Yes.
it's not for me to speak for you. Sorry.
Yes. Thank you, Pascal. So no, yes, Maria, we are only looking at what is feasible. Where the Union has competence, but we are not looking at politics. So we are proposing things that you might, we will propose amendments that you might think not viable for political reasons. But this is not for us to worry about, because we want to have a scientifically grounded solution which will favor the achievement of human rights, because this is also the proposal. The proposal is about human rights. So to the extent that human rights are principles that belong to substantive law, yes, we will look at substantive law, but only to that extent, and provided that it is within the competence of the Union. Okay.
So,
Yes.
yeah,
the project is called Foreseeable Amendments to the Proposal, and that means that we look at the proposal and then we amend part of the proposal, meaning rules within the scope of the proposal, and we analyze whether those rules are feasible. As Daria said, not from a political point of view, but from a legal point of view. But we don't go into the debate to regulate surrogacy or multiple parenthood, etc. We only came to it because a discussion went to it, but we don't go to creating substantive rules. That we also, I mean, that would be another project.
Yeah, indeed, and maybe that's exactly what I wanted to say. The ELI could have decided or might decide in the future to have a, a substantive family law project or an filiation project, and go forward with that. But that's not exactly the proposal as such. It's a limited proposal, and the sign that this is a limited proposal in a way, project, is that the title is very long. So it means things want to be clarified in the title, which is not always the most easiest thing to do. But I think that this kickoff webinar helped to understand what is at stake. And of course, during the next 2 years, during which this project will go on, there might be also changes in aim and understanding, so that it might be interesting to compare this initial kickoff webinar with what will be at the end of the day the outcome of the discussion within the European Law Institute, with the co-reporters, the ELI team on the project, the advisors, and the ELI Council, and the membership that will vote in the end, so that everything has an impact in the shaping of the end result, which we hope to be able to deliver as quickly as possible. It is my pleasure to thank you all, dear panelists, because I have the impression the discussion was not only very rich, the webinar. And therefore, thank you very much. I wish to this project a lot of success, and because that's what is at the core, of course. And I look forward to meeting you again for a further webinar, or to any interaction with the European Law Institute further down the line. Have a wonderful week, and see you soon. Thank you very much. Bye-bye.